When these are sworn under oath, that means you're telling the truth about the basis of why
Correct.
you're pursuing it, right? Because these
Correct.
have implications on people. And
Of
I'm
course.
only holding you accountable because, let me ask you, is this your ex-boyfriend or not?
Your Honor, that's irrelevant. He signed a lease which matches.
It makes sense because he's alleging that he did not sign a lease and that he is
He did
very.
sign the lease.
Did you move in together? Did you guys live together?
Yes.
Yeah.
Regardless of your relationship status, did you occupy another property or did you occupy the property with him?
I also occupied another property.
Okay, did you live with him?
Yes.
All right, folks, let me get you guys to unmute and raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
Absolutely.
I've read the pleadings, the filings. So, Miss Riviera, did you have a lease with Mr. Lauderdale?
Yes, sir. Would you like me to present my evidence now, or would you like me to do a brief summary of the situation?
Well, hold on. Let's see. I'm just going to ask a couple of questions and then I'll figure
Sure.
out because I didn't see in the file. Let me look for the exhibits. Did you already file those exhibits with the court?
Yes, Exhibit A should be the lease agreement. Exhibit B should be the statement of accounts of payments from Mr. Lauderdale. Exhibit C is the outstanding balances and damages.
I don't think I see those.
There were two of them were sent last night.
Let me ask you, when's this lease? When did you have a lease with Mr.
I have a
Lauderdale?
term lease agreement duly executed on July 15th, 2023, specifically demonstrating a term lease for approximately 4 years until 2027. The payment of rent due is $14.75 per month. Violation of the lease provision by engaging in unlawful activity, specifically the illegal sale of a Schedule 2.
Hold on. Is there a late fee?
Yes, sir. There's late fees and I've been
No. Well,
$40.
is there a monthly late fee amount?
Yes, I've been generous in not, it's a daily late fee, and instead of calculating a daily late fee, I just did $40 per day. Otherwise, I would go over the $15,000 max, but it
Well,
is
there is no max in dispo, but it's capped at late fees are $147.50. So a month. That's
$40
fine.
so we could do the max at $140 per month.
And so when's the last time he made a payment to you?
Last time he made he shorted payment from the date, I have short payments from the date of the beginning of the lease that he executed. So that amount is $4,000 total balance due.
And so you filed this dispossessory in February. You indicated at the time that the tenant is holding the premises beyond their lease term, and you indicated that there was no money behind. So you're now indicating that he's $4,000 behind, but that's not what the complaint says.
Oh, I'm sorry. I didn't have enough room to put the amount that he was behind after I calculated everything. So he is $4,213.16 behind.
And how do you come up with that?
That is, I took the spreadsheet of all his payments and deducted the $14.75 payment that he was supposed to make, deducted the payment that he did make, and the balance due is listed on a spreadsheet. I could share it with the court.
Well, no, not yet, because that
Okay.
seems to not be consistent with what you put in your complaint. So I
Okay.
want to understand why there's a difference, because that's not what it indicates on your complaint. So when's the last time he made a payment to you?
He made a payment in January, I believe.
Okay, you made a payment in January. How much was it for?
The January payment, $14.73.84.
$14.73.
I believe that was.
That's in November.
I'm sorry, $14.73.84.
$14.73.84. Okay, so you're saying he's off by $1.16.
Correct. And then in December, he was off by 70. I'm sorry, and then I have October $55, $58, $6.43.
Are you saying this is what he's short or what he paid?
Short, correct.
Okay.
But he's been short since the lease.
Okay. And so when did you give him a demand of possession?
A demand of possession was requested verbally due to illegal activity of drug substance on the property on January 3rd. He had 3 days to vacate or go to therapy. I offered Mr. Lauderdale rehabilitation at my cost to assist him if he was struggling with drugs, which apparently he's been using drugs on the premises as well. I've also asked him if he's not able to go to rehabilitation, that he needs to vacate the premises either on a temporary basis until his behavior and conduct has been remedied, or he could continue staying on the property if he went to therapy. He left on the 5th. On the 6th, I had texted him asking him to, come back to get the remainder of his items. On the 9th, at 8 a.m., he had a 4-hour window to remove the remainder of his items. Mr. Lauderdale showed up at 10:30 in the middle of my conference call with counsel. Unfortunately, I had asked him to come back at a later time since he did not meet the 8 o'clock time frame. At which point then he decided to call the police because he had threatened to break down the door. I asked him to kindly refrain from calling the police and just go pick up the U-Haul, which he said he was going to have, which he did not have possession of at the time when he showed up. I think it was only reasonable to ask him to come back in a few hours when he had all the truck available to him so he could remove the items in a timely manner. However, with the one first officer attempted to mediate the situation, and then Mr. Lauderdale was not happy with the results, therefore requested a supervisor to show up. The supervisor stated to me that he was going to allow Mr. Lauderdale to break down the doors if he needed to get the remainder of his items. And I said I was not allowing him to come into the property, but that I just needed him to have whatever necessary means to transport the remainder of his items.
Let me just talk to Mr. Lauderdale. Mr. Lauderdale, do you have a lease with Miss Rivera?
No, I never signed one. It's my ex-girlfriend.
Were you living with Miss Rivera with this particular property?
I co-signed on the house.
Is your name on the mortgage?
No, not anymore. Took it off maybe like 6 months after.
He's indicating that you had a 4-year lease that you guys entered into. What's going on with that?
She wanted me to sign a lease, but I declined because she was trying to qualify for another mortgage to buy another house.
Do you currently live there now?
No, I moved out after I broke up with her on January the 5th and then came back to get my stuff on January the 9th, and then that's when all that ensued.
Do you have all of your possessions from the property?
No.
Okay, what possessions remain?
She has my old iPad, my phone, and then some of my grandmother's old things.
Okay, any reason why you aren't able to get into the property and remove those things?
She lives there and she would not let me come and get them.
As a police officer or hold on. Is there a police officer or anybody else has indicated that you can't go get them?
The locks have been changed. Nobody's told me that I couldn't.
Does Miss Rivera live there as well with you?
Yes.
So Miss Rivera, listen, this is what you submitted to the court. That the tenant is holding the house beyond the premises, which it was essentially leased to him. That's what you clicked. You didn't click
That's what counsel asked me to.
You don't have an attorney. So referencing an attorney or counsel is not relevant when there's no attorney here representing you. That's one. Two, you indicated that he's holding the premises beyond over the term. That's not even true according to your own statement because he had a lease, even though he's saying he never signed it, until 2027. You're also alleging under oath at this time, because that's why it's notarized, that he's not behind on rent, but that his term ended. This is the major...
Okay.
That's what it says, is that the tenant is holding said house and premises over and beyond the term which the same was rented or leased to him. That's not the case, because it's not 2027, it's 2025. The other issues that you're alleging is that he breached some type of situation here with him using drugs. That's an allegation. I don't have any evidence in my record to prove that. Moreover, I don't even have the lease that you said you submitted. And maybe we'll get that, but I don't have it.
That was the first thing.
That's not even what you put on the complaint.
Okay.
You understand? When these are sworn under oath, that means you're telling the truth about the basis of why you're pursuing it, right? Because these have implications on people. And I'm only holding you accountable because, let me ask you, is this your ex-boyfriend or not?
Your Honor, that's irrelevant. He signed a lease, which matches.
It makes sense because he's alleging that he did not sign a lease and that he
did sign the lease.
Did you move in together? Did you guys live together?
Yes.
Yeah.
Regardless of your relationship status, did you occupy another property or did you occupy the property with him?
I also occupied another property.
Okay. Did you live with him?
Yes.
Let me tell you this. You cannot lock him out the property. You cannot change locks unless you have a stay away order or something else. That's if either he's a tenant or he at least has right to be there until that has been extinguished. Have you sent him a demand of possession, not verbally telling him he needs to go to therapy? That's not going to be sufficient. Did you give him a 3-day notice indicating you've breached this term of the lease?
Correct.
If you don't do these things, then I'm going to cancel the agreement. And even then, you have to have some evidence because then it's just a basis of you saying it. And if there's no other evidence, if he hasn't been arrested, if you don't have any other evidence, and he's saying, well, let me ask Mr. Lauderdale, have you been using drugs in the property? Have you been selling drugs out of the property?
No.
Do we have any evidence, Ms. Rivera?
Yeah,
that he's been selling?
I do have evidence.
And what
I did not
evidence?
submit it to the court because it was irrelevant. We're talking about a lease and
But
not.
it's not irrelevant if that's what you're telling me, the basis of why you want to cancel the lease.
I did send him a notice to quit on the 9th, certified and via email. He accepted service.
Just because you send a notice to quit, it has to be a basis for the notice to quit. So if you're saying you
did.
want to cancel the lease, and that would have normally required a 60-day notice. Did you give him a 60-day notice canceling the lease?
No, under the lease terms, because he was selling drugs out of the premises, I wasn't required to provide a 60-day notice, but rather a 10-day notice, which I did.
But again, he's saying he didn't. That's just an allegation. So you understand that you saying it, any landlord could say you're selling drugs and then cancel everybody's leases whenever they so choose. You understand? So, and then moreover, let's just be honest with you. You didn't indicate that on the complaint. I'm not trying to be difficult with you, but I'm looking at this in the totality of the circumstances. And it sounds as, especially when you're talking about he needs therapy or may come back, you've put that out there in the court. We didn't put that out there. That's the information that you shared with us.
Correct.
I'm telling you this, what you've submitted and the allegations that you've made are not consistent with the complaint that you filed.
I'd be more than happy to file an amendment.
Well, no, the case is I'm gonna tell you what's gonna happen. You're going to be in a bad situation if you don't let that man in the house and get the rest of his belongings.
There's
You do
nothing
not
here,
have,
sir.
and again, he's still a tenant if that's what you want to allege. He still has a right to be in the property. Based upon your own statement of a 4-year lease, until there's a writ of possession issued, you don't have the right to prevent him from entering the property. That's probably why the police got upset with you and told you that he can enter the property and get his possessions.
I wasn't not allowing him to enter the property. I did. I was in the middle of a conference call with counsel.
But there's no reasons why the lock should have been changed to where he couldn't
The
gain it.
locks weren't changed. A code
Well, then
was
there's
changed.
no
He doesn't have keys to the house.
That's problematic if he's a tenant. Do you understand? And
Yes,
I
ma'am.
want you to
Yes,
know
sir.
this because if you continue to rent to people and you continue this kind of behavior, the court very well it may admonish you because this does affect people. And if
Of
it's not
course.
done correctly, then you can have a negative consequence on somebody. I understand maybe your
Absolutely. I know
intentions are
that.
pure, but the way you're going about it is improper.
Okay.
So one, we don't have a situation where he's holding the premises beyond his term. 2, if you have a lease, I'm still waiting on the lease. Let me see if the lease ever came to me.
Would you like me to forward the email with the lease?
Hold on, I think someone just emailed it to me. I see some payments made. And you're telling, just to confirm, Angel Eyes is who you're saying you made the lease agreement with.
Correct. I'm the sole proprietor of Angel Eyes LLC.
There, Angel on this. So,
And Judge, if I may, I paid my half of the mortgage and utilities every month since I lived there. I have invoices that she sent me for the exact amount that I paid.
that you paid, I see.
That's what I
And
listed. in
this
the-
1475 is just concocted. I
it
paid
is.
my half of the mortgage.
Well, Ms. Rivera, I still don't see excuse me here. I still don't
Would you
see.
like me to forward you the lease, Your Honor? I did.
Well, I'm going to be honest with you. I'm going to dismiss it because of multiple things. But one, what you've alleged in your affidavit and complaint is not exactly the basis of how it is. If you're
Okay.
alleging that there's another reason, you're going to need to refile to allege that and make sure that you give them
That's
the
fine.
proper notice. And then as well submit, because the information that I've received from you in the email is just a pay ledger, but it does not actually have the lease. And even if that's the case, you gotta go about it appropriately. You know,
Yes.
if it's not a default, then you need to give them a 60-day notice to cancel something. But right now, you're really in a problematic situation because he's saying he still has property there and you've changed the codes or locks or whatever it is. And until you get a writ of possession, until something else has happened, he can be there, whether you like it or not, because you've made that agreement for him to be there.
Absolutely. And this is the process that I've been trying to go through because he's forced me to do this. So therefore, I've tried to negotiate. Not a big deal. I could refile. I'll have my attorney properly file the complaint in an appropriate manner so that there's no miscommunication about the situation and what needs to happen.
Okay, but don't lock him out, because if you change codes and things, I'll be frank with you. Normally
He needs to come and get his dog.
You guys have a relationship issue, but if you're going to use the court, make sure you use it correctly, because this is not a place to air out your personal business. I don't tolerate that. So I'm going to let you guys go, but it will be dismissed. Please, if you come back, do it right.
All right. Thank you, sir. I appreciate it. I'll refile. Your Honor, do I have to reserve him then if we have to refile then? Is
Yes,
that
ma'am.
correct?
That's
No
correct.
worries. Thank you.